Since its establishment, access to justice has been a driving value of Trinity FLAC, and as such we are thrilled to be hosting the speaker event entitled Civil Legal Aid Review. Earlier this year, the Department of Justice commissioned a review of the civil legal aid system in Ireland, under its current strategic objective to improve access to justice and modernise the court system. In response, following an extensive period of prior campaigning for this review to take place, National FLAC was joined by a number of NGOs, charities and non-profits in calling upon the Minister for Justice to deliver a comprehensive review of the system. Collectively, these organisations work with migrants, travellers, members of the Roma community, deaf people, lone parents, persons with disabilities, victims and survivors of domestic violence, unemployed people, the working poor, and more, with the common thread amongst these being the experience of unmet legal need that is not addressed through the current civil legal aid system in Ireland. Consequently, FLAC is advocating for a root and branch review to scope and map this unmet legal need. In advance of the findings of this review, Trinity FLAC has chosen to organise a speaker event where we are joined by two phenomenal advocates who have worked extensively within this sector and bring valuable insights into providing legal support and services to vulnerable and marginalised communities. Initially, we will hear from Christopher McCann, head of FLAC's Traveller Legal Service, who will be discussing their work and highlighting the current inadequacies within the civil legal aid system in meeting the needs of Irish travellers. His valued contribution touches on the practically insurmountable structured barriers to travellers in receiving sufficient and timely legal aid in cases related to housing and evictions under the Civil Legal Aid Act 1995, amongst other things, and emphasises directions reform of the system ought to take. You will then hear from Professor Gerard Whyte of the Trinity Law School, a long-standing supporter and friend of Trinity FLAC. Professor Whyte is highly regarded and widely published in the areas of public interest law, constitutional law, trade union law, and social welfare law. He has worked extensively throughout his career with social justice and legal aid organisations, including the Mercy Law Resource Centre. His contribution to this event centres on social welfare law under the civil legal aid system, particularly the exclusion of its provision before the Social Welfare Appeals Tribunal, which has significant repercussions for vulnerable and socioeconomically disadvantaged parties. We hope that this event provides further information surrounding civil legal aid in Ireland and insight into its upcoming review.
My name is Christopher McCann. I am a solicitor with the Free Legal Advice Centres and I work in its Traveller Legal Service. I'd like to thank Trinity FLAC for inviting me along to discuss the review of civil legal aid. My contribution will be based upon my experience working as a solicitor in the Traveller Legal Service. Since its establishment, the Traveller Legal Service has received 104 referrals and provided representation defined as entering into proceedings or pre-action correspondence in 29 cases. Referrals related to accommodation, evictions and discrimination predominate the inquiries received by the Traveller Legal Service, and as a consequence, the cases in which the service has provided representation. Considering therefore that these three issues are, in our experience, the justiciable areas or issues most likely to affect travellers, what are the barriers in the current scheme of civil legal aid that travellers face in obtaining representation and advice? In the remainder of my talk, I will discuss 4 such barriers, 2 of a legislative nature and 2 of a practical nature, which prevent travellers from accessing legal aid in cases related to accommodation, evictions and discrimination. The first and most obvious barrier is the absence of civil legal aid for cases which are before the Workplace Relations Commission. Under the Equal Status Acts 2000 to 2018, a claim for discrimination in the provision of goods and services, discrimination in relation to the disposal of accommodation, or in the provision of educational services, or discrimination in relation to clubs must be brought in the WRC. However, legal aid is only available in such tribunals as opposed to courts, as have been prescribed by ministerial order pursuant to Section 27 2B of the Civil Legal Aid Act 1995. Currently, the Workplace Relations Commission is not so prescribed, and consequently, legal aid cannot be provided to parties appearing before it. Therefore, a traveller, or indeed anyone wishing to challenge discrimination in the absence of representation of their own, must represent themselves, and this is often against legally represented opponents. Although the WRC was intended to be a more user-friendly forum than a court, the law it considers is no less complex. The Equal Status Acts are underwritten by European Union legislation, the consideration of which is necessary to argue a case, and expecting an individual, particularly an unrepresented individual, to do so has, in our analysis, two negative consequences. First, at the individual level, it lowers the likelihood that the applicant's case will be successful, particularly if their opponent is represented. And secondly, at a broader and what might be termed systemic level, it hinders the development of a sophisticated equality jurisprudence, which is best achieved through trained lawyers contesting cases and developing the law. Addressing this barrier would, in legislative terms at least, be a straightforward exercise and would simply require the introduction and passing of a statutory instrument to prescribe the WRC as a tribunal in respect of which legal aid is available. This is a measure which FLAC supports and one which it has recommended on numerous occasions. The second legislative barrier relates to Section 28(9)(a)(2) of the Civil Legal Aid Act 1995, which provides that legal aid shall not be granted in respect of disputes concerning rights and interests in and over land. Apart from discrimination cases concerning housing, accommodation and evictions form the majority of the referrals received by the Traveller Legal Service. Since its establishment, they have comprised 64% of the referrals and 58% of the cases where representation has been provided. As such, it can fairly be said that accommodation and evictions are the greatest areas where there is unmet legal need, or the areas where there is the greatest level of unmet legal need for the traveller community. However, due to the wording of Section 28(9)(a)(2), the extent to which legal aid is available for such cases is unclear. Unfortunately, there is no guidance in the Act or in the Civil Legal Aid regulations as to the parameters or exact definitions of the wording of the section. Nor has it been subjected to judicial scrutiny, resulting in an authoritative interpretation. Accordingly, it is difficult at the point of applying to know whether or not legal aid will be made available, and that is even before the merits of the case have been considered. Whereas certain accommodation issues, such as standards in traveller-specific accommodation, would not appear to meet the definition of a dispute as to rights and interests in and over land, other important issues, such as the failure of a local authority to provide traveller-specific accommodation at a particular site, pursuant to the local authority's obligations under the Housing Code, seem more likely to be caught. Evictions from unauthorised sites appear yet again to fall more squarely within the definition of a dispute as to rights and interests over land, particularly where prosecuting such a case would necessarily involve the invocation of ownership rights, and defending such a case from the perspective of the traveller may or should or usually would involve the invocation of human rights arguments. Travellers living on unauthorised sites, many of whom will have been there for years, are subject to at least 5 separate legislative mechanisms, which can be invoked by the local authority or the Gardaí with little or no prior notice to the traveller, and carrying with them the threat of a caravan being seized and/or prosecution for non-compliance. In many cases, travellers against whom such provisions are invoked actually have protective rights pursuant to Article 8 of the European Court of Human Rights. However, the presumptive prohibition against the provision of legal aid in such cases leaves travellers at the mercy of state bodies with practically unlimited funds and in a position where they are unable to effectively assert their rights. And in common then with the absence of legal aid in WRC cases, a negative knock-on consequence of this is that rights jurisprudence in the state generally remains undeveloped. FLAC has recommended amendments to the Civil Legal Aid Act 1995 which would allow for legal aid to be provided in circumstances where the dispute relates to land which constitutes a principal private residence or a family home. The third barrier is a practical barrier and relates to the speed with which legal aid is currently provided. If we assume for a moment that Section 289A2 was interpreted so as not to deprive travellers facing eviction of legal aid, or was amended in accordance with FLAC's recommendations, it would yet be questionable whether the current waiting times for an appointment would facilitate effective advice. In its last annual report, the Legal Aid Board recorded that the waiting times for a first appointment at law centres throughout the country varied from between a minimum of 7 weeks to a maximum of 52 weeks. So where an eviction notice is served providing no or perhaps 24 hours notice to move, an appointment 7 weeks hence would be of very little use. It should be noted that the civil legal aid regulations do contain a procedure for emergency legal aid certificates, which themselves entail a truncated application process. However, there's very little data in the Legal Aid Board's annual reports or otherwise, which indicates how often these are used or how available they are. So whether or not these present a viable avenue for travellers to get legal aid in cases of eviction, even accepting the prohibition discussed earlier, is difficult to determine. The fourth and final barrier I would like to discuss is a further practical problem and relates to the manner in which legal aid must be accessed. Naturally, to access legal aid, one must first apply. However, the legal aid application, which can be filled out in person or online, requires the submission of details in relation to legal dispute, personal details, financial details, and the appending of supporting documentation. And in FLAC's experience, travellers and other vulnerable groups may struggle with such an application form, particularly where there are literacy issues, digital literacy issues, language issues, or even the absence of consistent access to the internet. So in addition to the recommendations I've already covered, FLAC thinks that the Legal Aid Board should consider simplifying its application process for certain applicants at least. So those are 4 barriers which I have come across in my work providing legal services to the travelling community. The Department of Justice is currently reviewing the scheme of civil legal aid, and it is hoped that some or all of these recommendations are addressed as part of that review. Thank you very much.
Let me begin by saying how delighted I am to be asked to contribute to this review of the civil legal aid scheme organised by Trinity FLAC. This event is particularly timely given that the Department of Justice has given a commitment to review the civil legal aid scheme and to bring forward proposals for reform. It is now more than 40 years since the state first provided civil legal aid, and the Department's review of the current scheme is greatly to be welcomed. In my opinion, an essential element of any such review would be the carrying out of comprehensive empirical research into unmet legal need in Ireland. Such research has been carried out in the past in this country by Sue Gogan and Maureen Ryan, by the Northside Community Law Centre, now Community Law and Mediation, by Ballymun Community Law Centre, and by FLAC. But all of that research was focused on specific neighbourhoods. Comprehensively empirical research, such as that carried out by Professor Hazel Jenn in England and Wales in the late 1990s, is now essential to help us understand how people respond to justiciable problems and how access to legal services might be enhanced. In 1977, the Pringle Committee identified 4 factors that deterred low-income individuals from accessing legal services. There was the factor of cost. There was the issue of doubt on the part of people as to whether the law was relevant to the problems that they were experiencing. There was also the existence of a psychological or cultural barrier between people from disadvantaged neighbourhoods and the world of the law. And finally then, there was an issue of difficulty in accessing solicitors' offices, especially in Dublin, where the solicitors' offices were located in the city centre at that time. Now, time has moved on, and this analysis of the barriers of accessing legal services needs to be revisited. Given the significant increase in the size of the solicitors' profession since the 1970s, it is probably unlikely that the last factor identified by Pringle, difficulty in accessing solicitors' offices, that is quite as relevant today as it was back in the 1970s. As against that, there's at least one new factor not mentioned or identified in Pringle, which may constitute a serious barrier to access today. And I'm referring here to the issue of digital exclusion, the fact that some people do not have ready access to computers and computer technology. And this is an issue that has been exacerbated by the COVID pandemic, which prompted a significant shift towards online services. In that context, I want to commend Trinity FLAC for the excellent analysis of this issue that they provided in their research report, Technology and Access to Justice, published in 2020. Identifying the factors that impede access to the law is critical for any legal aid scheme. To the extent that factors other than cost, factors such as a lack of awareness of legal rights or a feeling of being intimidated by the legal profession, to the extent to which those factors impede access to the law, then the solution to this problem is arguably to provide a strategic model of legal aid. Now, a strategic model of legal aid does not confine itself to facilitating clients in bringing litigation, but also engages in programs of legal education for disadvantaged communities, raising awareness about legal rights. Moreover, the services of such a model are often delivered in the disadvantaged neighbourhoods themselves in an attempt to make the law less intimidating. And the lawyers involved also engage in campaigning for legal reform for the community generally, not simply on behalf of their individual clients. The strategic model is contrasted with the service model of legal aid, which focuses primarily on the issue of the cost of legal proceedings. According to Siemens, the service models focus their attentions on the discrete claims of individuals who have a readily categorized legal problem. And such models grow out of the traditional approach to protecting rights, which is essentially legalistic and individual. Siemens added that because they are inevitably overloaded, service models can expend little time or energy in educating the community or on outreach programs. And then he continues, since service models accept the norms of the legal system and provide a service for poor people, which, in the opinion of the administrators, is the same for the poor as for the rich, poor people using service schemes face many of the same obstacles that they would encounter within the traditional setting. Such service models offer little recognition of the uniqueness of the poor person's lifestyle. They neither make the service psychologically more accessible, nor do they attempt to handle problems which have not been on the traditional agenda of legal services. The service model reinforces the distance between the recipient and the deliverer of the service by encouraging clients to assume passive and dependent roles in their relations with the legal aid scheme. Lawyers write briefs, interview witnesses, negotiate settlements, and go to court. The client's perspective is generally of an overworked, underpaid lawyer who is dealing with the immediate problem and ignoring the fundamental cancer of poverty and poverty-related problems that continue to affect the client. End quote. In the Irish context, the strategic model of legal aid has dominated the not-for-profit sector, and organisations like FLAC look beyond the servicing of individual cases in order to maximise the impact of legal aid work on social and political reform. Thus, over the years, FLAC has successfully campaigned for reform in the areas of family law, employment law, social welfare law, and consumer law. Moreover, FLAC's use of a litigation strategy has secured worthwhile gains for disadvantaged people, notably in relation to improvements in the criminal legal aid scheme, in the implementation of the third European Equality Directive relating to men and women in matters of social security, and more recently in relation to reform of the law relating to transgender people. FLAC has also done very important work in disseminating information about legal entitlements both to individuals and to other NGOs. From the 1990s onwards, FLAC augmented this valuable role as a legal resource to other organisations through its provision of specialised training for community and advice workers. And in its work through the Public Interest Law Alliance, FLAC is building an important infrastructure with partners in the legal profession and the voluntary sector that enhances the role of the law in tackling social exclusion. Organisations like Community Law and Mediation and Ballymun Community Law Centre do similar types of work and also locate the delivery of their services in specific disadvantaged neighbourhoods so as to minimise the cultural or psychological barrier between disadvantaged individuals and the world of law. In contrast to the strategic model used by the not-for-profit sector, the legal aid scheme operated by the Legal Aid Board is a service model of legal aid and is not designed to address all of the factors identified by Pringle that impede access to the law. In particular, the board does not play a significant role in educating the public about their legal rights, and neither are its offices located in specific disadvantaged neighbourhoods. It is to be hoped that a comprehensive analysis of unmet legal need in Ireland, if carried out as part of the Department of Justice's review, might prompt some fundamental rethinking about the most effective way for the state to facilitate disadvantaged individuals and their communities in securing access to justice. However, even if such a review does not prompt such fundamental rethinking, there are still a number of reforms within the paradigm of the service model that would significantly enhance the state civil legal aid scheme. In the first place, the current scheme is not comprehensive. Cases going before social welfare appeals officers and employment cases going before the Workplace Relations Commission are excluded from the scope of the scheme, as are representative actions and test cases. In addition, the exclusion of cases concerning rights and interest in or over land precludes the board from representing public sector tenants in disputes with housing authorities and from representing travellers allegedly trespassing on public or private property. Moreover, the failure to provide for periodic review of the financial limits on eligibility raises the prospect that inflation will restrict the category of eligible applicants. It is clear, therefore, that the present scheme is still quite restrictive, and this raises the question of whether Ireland has complied fully with its obligations under Article 6 of the European Convention on Human Rights. In Erie versus Ireland, the Court of Human Rights held that the state had to provide for legal assistance, quote, when such assistance proves indispensable for an effective access to court because of the complexity of the procedure or of the case, end quote. It is certainly arguable that at least some indigent litigants involved in complex litigation here will be unable to obtain legal aid from the state because of the restrictive nature of the statutory scheme, and that consequently Ireland may still be in dereliction of its international obligations. Of course, even full compliance with ERI does not mean that Ireland would have the most effective legal aid scheme possible, given the limitations of the service model of legal aid. In that context, the collaboration of the Legal Aid Board with Ballymun Community Law Centre as part of the regeneration of the community of Ballymun is to be welcomed as an indication of how partnership between the board and community law centres might yet produce a mixed delivery model of legal aid combining service and strategic elements. In conclusion, I would again like to commend Trinity FLAC for organising this review of the civil legal aid scheme. Mahatma Gandhi once said, "Think of the poorest person you have ever seen and ask if your next act will be of any use to him." With this focus on the need to reform the civil legal aid scheme, Trinity FLAC are certainly acting in line with Gandhi's exhortation and are living up to the best traditions of the legal profession.